Hey everyone, welcome to episode one of Ann David Limited Presents. My name is David.
And I'm Lauren Ann from Ann David Limited. And our company, the goal is to educate the masses on financial literacy. We really want to help you guys to manage your money, to pay off debt, to invest, and to overall build wealth. And so with that goal, that in mind, we'll talk about estate planning today. And we think it's really imperative, especially in this climate, to really talk about estate planning because, quite frankly, financially and even health-wise, there's a lot of uncertainty. We're in the COVID-19 era. So this is a very, very imperative topic. I am really, really excited to talk about it, even though, it can be kind of interesting to traverse to talk about death and that sort of thing. But we're very excited. And with that note, I'll have David introduce our guest.
Yes, but before we begin, we have a disclaimer. The information discussed here today does not constitute legal advice, but it's more so just for general information and to educate you about estate planning. Further, the views, thoughts, and even opinions expressed here are solely of the host and the speakers and does not necessarily constitute the views, the thoughts, and opinions of the host or speakers, employer or organization. But without further ado, we're excited. We have an amazing guest on the show today, an expert in the field of estate planning. Like Lauren was saying, this is a very important topic. And we find that there's so many myths and misconceptions concerning estate planning. Mm-hmm. And our guest is going to dispel those myths and misconceptions and really educate us on the importance of estate planning and why we should be considering estate planning right now. So without further ado, we're going to introduce our guest, our distinguished guest, actually, Kamala Richardson.
Round of applause, round of applause.
Fun. Thank you.
Hi, Kamala.
David, for having me.
Of course, Kamala. We're excited for you to be on the show. And this is our first episode ever of Ann David Limited Presents. So we are excited to have no pressure at all, actually.
I know, right?
But before we begin, Kamala, if you can just give everyone an introduction to who you are, what you do on a day-to-day basis, your credentials, really.
Okay. All right. Of course. My name is Kamala Richardson. I am an attorney, and my primary practice area is private client and wealth management. And within that head comes estate planning, of course. So I advise my private clients on a variety of wealth and estate planning matters, including setting up, drafting their wills, establishing trusts, establishing, other sorts of wealth management and estate planning vehicles like private companies, foundations, a wealth of structures, of course. And I guess on a day-to-day basis, you can find me doing any one of those things. And what I love about this area of practice is that, it really is a sort of, the person-to-person interaction, I get to meet with clients, I get to sit with them, I get to hear their life stories, I get to hear their objectives, their hopes and their dreams for the future and for their future generations. So yes, it's very rewarding in that sense.
Mm-hmm. That's awesome.
Yeah. So I guess the first question we have for you, and for most people, if they don't know, what is estate planning and why is it?
Okay. Well, estate planning. Let's look at the words themselves. Estate planning is essentially setting up a plan, putting a plan in place for your assets in the event of your inevitable demise, your death. It's something that's going to happen to us all, or in the event that you become incapacitated. So ensuring that there's some plan for the succession of your assets, planning to whom those assets should go, how they should go, attaching any sort of terms and conditions you might want to the succession of those assets. Now, of course, this is in this time, as Lauren would have mentioned at the start, it is crucial given the prevailing circumstances, given COVID, because one thing we've learned in this past year is the fragility of life itself. And I know many of us think that, we'd like to think that we're going to live, just forever, for eons and eons, but unfortunately that is not the case. And eventually we're going to have to come face to face with our own mortality. So in that vein, it's always good to plan ahead. And I would say that, what I like to see most in my practice is people my age, which I don't get to see quite often, a millennial like myself, coming in and thinking about, their estate planning, what should happen when, to their assets when they die, because you will know that we're now at the age where we're starting families, where we may have children, and you need to put structures in place, contingencies in place, in the event that should something happen to you, your children are well taken care of. Or even if you don't have children, or if you have, let's say parents that you want to sort of add to their retirement, that you do that as well, so that just generally passing the wealth on.
Right.
It's interesting you mentioned something. You said you wanted more millennials to be coming into your office. What in terms, so that leads into, I guess, the next question. The demographic of people that you find coming to you, who are they?
Well, I would say primarily the bulk of the people that
what are some of the...
Oh, sorry.
Go on, sorry.
For a second, but go ahead.
No, we're just saying that the demographic of people that you see on a day-to-day basis. You mentioned that you would want to see more millennials. And so maybe there's, I guess, a lack of education in terms of the importance of it. Or like we mentioned, there's some myths and misconceptions surrounding it. And that's maybe the reason why we don't get a lot of young people actually seeing the importance of it now. So if you could just touch up on that, maybe some of the, I guess, reasons why you think young people are not taking it seriously or prioritizing it right now.
Well, firstly, let me start with your demographic question. Primarily, the type of clients that I see, most, at least the clients who want to talk about estate, and I'm not going to talk wealth planning in general, but just estate planning. You tend to see older clients, I would say people of our parents' generation come in. And then after that, you get a lot of, I think it was Generation X, who was the generation before us. I see a lot of them because, of course, they've acquired a significant amount of wealth. I read some study quite recently saying that the greatest wealth transfer in our lifetime would have been the transfer of wealth between the baby boomer generation and the Gen X generation. So, of course, you can understand why those are the people that I tend to see. But of course, millennials, we're up and coming, we're starting to thrive within our careers and to acquire assets. So now it's time for us to start thinking along the same lines that, our predecessors are thinking about, putting plans in place for our future, for our children's futures, just so that there's that smooth transition, that smooth transfer of wealth between us and the generation, our offspring, essentially.
Do you think that there is certainly more talks like this can help people our age to fully understand the importance of, drafting a will or POA, power of attorney? But can you think of any other, I guess, tips or strategies that people our age can do to encourage each other to really think hard about it, I guess, and really do it?
Well, what I think needs to happen is we need to get comfortable with having that sort of open conversation about our eventual demise.
That's
true. Possibility that we may become incapacitated at some time. I mean, I very well know people my age, our ages, who have in fact become incapacitated. I know people our age who have, unfortunately passed on, as early as we may think it is. It is a very human event. But I think, yeah, so long as we begin to sort of adopt, to sort of shift the culture, in other words, to, sort of let go of those superstitions. I mean, I love Bahamian folklore and superstition. Unfortunately, sometimes it has the effect, the unintended effect of, holding us back and keeping us from sort of progressing, for lack of a better word, as a society. But we need to start to make it, like I said, and make it. It should be an open conversation.
Yes.
And actually, in saying that, just to add to your point, Kamala, I think that it also needs to start within the home. I know a lot of parents, they think talking about money and death is very taboo, but you'll find a lot of wealthier societies or people of the upper crust, quite frankly, they sit down with their kids and they talk about money management. They talk about what they have, the estate. They're not ashamed to say, this is what mom and dad has, and this is what we're going to give you when we pass on. So I think, on a nuclear level, somehow we need to make the shift to have mothers and fathers sit down with their kids, their teenagers, and talk to them about money management and whatever assets they have. Talk about it. It's a learning experience. So at their level, of course. So I think that's a really good point you just stated. So hopefully one day we can get to that point.
I couldn't agree more, Lauren.
Yeah.
So Kamala, we talked about the importance of it, estate planning. Before we, I guess, get into the estate planning vehicles that exist, what are some of the things someone comes to you and they say, okay, I want to start estate planning? What are some of the things they need to start considering before even choosing an estate planning vehicle?
Well, first and foremost, what you need to look at is you need to look at your present sort of family structure, and also you need to consider your anticipated, family structure. You need to figure out, do I have children that I want to provide for? If I'm not going to have children, which is, perfectly fine, who do I want to sort of benefit from the assets that I've amassed? Do I want to pass them on to, my parents, or do I want to, let's say, do I want to pass them on to nieces or nephews? You need to look at your family, your present circumstances, as well as think towards your future circumstances, and sort of make that decision of, where do I want, these assets to go? Should I die? Or should I become incapacitated? What would I want to happen? You also need to, apart from your familial structure, you should also start making an accounting, what all do I have, and putting a plan in place as to how I will invest and acquire more. So that's why it's so important to work on your financial literacy, as you guys are promoting, as well as to work with financial advisors who can direct you in terms of investing and ensuring that you preserve not only preserve what you have, but you generate more.
Okay, well, that's really cool. I think in terms of because when you go to a lawyer, I presume they're going to ask you, okay, give me a list of all of your assets, give me the current value of your assets, where are they all located? So to have I think even a spreadsheet or even just a written list of everything that you would want to put in a will and the value, I think is very useful, and also for you to keep track of, also to get net worth is. That's a kind of separate topic but related. And I wanted to know, because we had mentioned earlier, sitting down, talking with your kids to teach them about, your assets and money management. In your experience, do you think it is wise, or is it based on the family dynamic to, I guess, tell the beneficiaries prior to your death what they will be receiving, or should it more or less be a surprise?
Mhm.
Yeah, I don't know. What have you seen in your practice?
Well, to me, it honestly does depend on you strictly, and what it is that you want. My whole thing is, you may very well want to alert certain persons that, this is what you're going to leave for them, so that they develop, some sort of sense of value of the item, or you may want to refrain from doing that, because on the other side of the coin, I can tell you, you're inheriting all of my assets, and you never know what sort of impact that is going to have on the particular person. I might be dealing with a spendthrift beneficiary who, because I said that I'm going to leave these assets to them, they make the personal decision to sort of fritter away their own assets.
Mm.
So it really does depend on you as a person, what you feel most comfortable doing, as well as the people who will benefit from your estate. What are their personalities like?
Right,
Mhm.
right. Yeah, that's very
That makes
important.
sense. Yeah.
Yeah. So, Kamala, we're just going to, I guess, dive straight in
Yeah.
into one of the most popular, I guess, estate planning vehicles. I think most people know what a will is, for the most part, but just for those who may not know what it is, what is a will?
Well, essentially, and I'm going to try to speak in completely layman's terms. I don't want to get too technical. Essentially, what a will is, it's a document that records your wishes as to your assets, as to who will inherit your assets upon your death. So, in its simplest terms, that is what a will is.
Right.
Mhm.
And in terms of, I guess, creating a will,
Mhm.
who can actually create a will?
Mhm.
Is there age restrictions or anything?
Of course, there are. Of course, you must be 18 years of age or older, and you must be of sound disposing mind, meaning that you must have the mental capacity to create a will, and that is to understand at the time that you are creating your will what it is that you're doing.
Right.
Mhm.
And yeah, sorry, we're just so excited. We're going back and
Tons of
forth. We
questions.
want the information. But Lauren, you go ahead.
Yeah. So, I guess people want to know: are there restrictions as to what I can put in a will? What's the law specifically for the Bahamas say around what I can put in a will?
Mhm. You mean are you speaking in terms of assets, or are you speaking in terms of the specific actual terms of the will?
That's interesting.
Well, I guess both. Yeah.
Yes.
Yeah.
Well, in essence, when you're talking about the actual specific terms of the will, I will say that I've met a number of very colorful clients during my years of practice, and they love to, go on these long. They have like to have these long treatises in their will. Just describing who they are, what it is that they want to do before they even get
Higher dissertation.
positive. And in essence, there is nothing wrong with that. So there's nothing wrong with that, so long as at the end of the day you have a document that meets all the required formalities of a will, in that it's executed as it should be, meaning it's signed as it should be. It's signed by you in the presence of two witnesses, and of course, neither of those witnesses should be persons who are to inherit an interest in your estate, and neither should they be the spouses of persons who are going to inherit an interest in your estate. And yeah, just so long as it meets those sort of formalities, so matter as long as you have dealt with the assets in the will properly. For instance, a common mistake that you will find is people will forget about what's called the residuary estate, meaning that after I've made specific gifts to people in my will, everything else that's left, people will often forget about that. And what they don't realize is that under the law, if you leave that out of your will, then essentially the law regards you as intestate, meaning that you do not have a will in relation to that portion, and then that portion of your estate will sort of devolve in accordance with the inheritance laws under the Inheritance Act. So it will devolve outside of your will. So the Inheritance Act, for instance, states that upon intestacy, for instance, if I die and I leave no will.
Sorry to cut you off, Kamala, but
okay, go ahead.
you don't know, the word dying intestate means you simply died and you don't have a will, correct?
Exactly. Yes, you are correct.
If that occurs, then there's the inheritance law in the Bahamas that dictates how your assets are to be distributed by law, correct?
Yes.
Okay.
Yes. That's correct. And what happens under the Inheritance Act is, let's say, for instance, I die and I leave a spouse and I leave children. My estate will go 50% to my spouse, and the remaining 50%, for instance, will be divided equally amongst my children. So the whole entire, so under the Inheritance Act, there's quite a long list of persons who will inherit the assets in default. And I think it ends at, the very last tier of inheritance is your next of kin, if there's absolutely no one else.
Right.
Okay. Now I have a question, because I know we have probably some burning questions based off of what you just said. So, for example, there is a spouse who dies, does not have a will. So based on what you just said, automatically half of the assets go to the surviving spouse. The other half of the assets are equally divided between the children, correct?
Yeah, that's
so now the children does that include biological, adopted, inside, outside? How are the children defined? Or anyone that you have
basically
taken as a child but not your child? Yeah, what are the children?
Blended families.
Yeah, define that, the children.
All right. So under the Inheritance Act, as well as under the Wills Act, children includes not only legitimate children, but also illegitimate children, as well as adopted children. So long as the children fit in within any one of those categories, they will be recognized as children, as far as the state is concerned.
So that means that a stepchild who has not been legally adopted by a spouse who's passed is not entitled to any of their assets.
That is correct.
Okay, just want to confirm. Okay, because I know we have a lot of blended families. That's a very question. So in order for, in this case, a stepchild to receive assets of the spouse that passed, they would have to include a clause in their will specifically to will that child assets.
Yes, that would be very prudent.
Okay.
Got it. Okay. Good stuff.
Yeah. So I guess the next question is how frequent, well, first of all, once you create a will, can you actually change the will at any point in time? And if you can, how frequently should you be doing that?
Well, of course, once you've created your will, you are free to go back at any time to change it. So, circumstances dictate that you should make a change. So for instance, let's say I have another child after making a will, I may, and I don't, and I want to give a specific gift to that child upon my death. I can go back in, I can have my attorney sort of, make an amendment to my will by way of codicil, or I can redraft the whole thing entirely and, of course, make changes to it in that way. And another thing I should probably mention is that certain life events, and more particularly getting married, for instance, the effect of that on your will is that your will is revoked upon your marriage. So if you make a will prior to getting married, upon getting married, it's deemed revoked. The same thing happens when you divorce. So on the dissolution of marriage, once you divorce, if you've made a will prior to that, your will is essentially revoked by your divorce.
So just I guess to get a better understanding, you mentioned divorce. So let's say, for instance, will is created within the marriage,
Mhm.
correct?
Mhm.
You get divorced.
Mhm.
Is that will then, you're saying that will or is the will still valid per se, or is it
Yes.
completely?
The gift to your spouse, to your former spouse, under the will, in that particular instance, that gift would essentially be void.
Right.
But the gifts to the other persons would still be valid since there's no conflict or anything.
Yes. So your gifts to your children, for instance, would still stand.
Right. But it would be prudent to, I guess, in that situation, just to create a new will altogether.
Entirely.
Right.
Makes
Okay.
sense. Makes sense.
So you mentioned, well, we mentioned intestate, that came up just now.
Mhm.
And for those of you who are just joining, intestate means dying without a will being in place. And so what happens if you die without a will? You die intestate. What's the whole process? I guess court proceedings may have to happen.
Right.
What happens then?
Well, when you die without a will, what happens is that, as we mentioned earlier, the Inheritance Act dictates to whom your assets should devolve. So, in the case of dying without a will, an application needs to be made for a grant of representation to the Supreme Court, known as letters of administration. And essentially, that recognizes an administrator of your estate who is then entitled to dispose of those assets in your estate to the persons entitled thereunder.
Right.
Okay. So you're saying that you go to the court.
Mhm.
Okay. You file these letters of administration, which you've called them,
Mhm.
and so the court appoints someone who will now be in charge of that deceased person's assets and distribute them. So I guess who does the court normally appoint? Do they appoint a lawyer, a family member?
No, well, of course, it's not just anyone. In the first instance, if you're married, then it's your spouse. Then, of course, if you have children, then it is your children. If you're not married and you don't have children, then it would fall to your parents.
So it's interesting.
Okay. So normally a family member sounds like.
Right. But what
Okay.
happens in a situation where the court, there's a spouse involved, a widow, but for whatever reason, and I don't know if you've seen this before, she doesn't want to be appointed, or he doesn't want to be appointed as the representative of the estate.
Mhm.
Is it just the next of kin, the next person in line that is appointed by the court, or can you force someone at
Yeah.
all to
No, you
be an administrator at all of the estate, or?
No, you cannot force anyone. And of course, what would then happen is that the next person in line under the Probate and Administration of Estates Act, that's a specific piece of legislation that deals with applications for grants of probate and letters of administration in estates. It passes on to the next person. So if I say that I am unwilling to do this as a spouse, then the next group of persons, which would be the children, would then all equally be entitled to apply for letters of administration in that particular state.
Okay.
Okay.
All right. I think I just have two more points I want to touch on before we move on. The first one, I think we were discussing, we were curious to know if, I know they aren't advised, but if they are legally accepted, and that is DIY wills, meaning I sit down, I write down, I want that to go there, this go there, and then I write at the end, anything that I've left out goes to X person, I sign it, there's two witnesses, the witnesses aren't beneficiaries or a spouse of beneficiaries, it meets all the formalities. In the court of law, does a DIY will stand?
Yes, of course it still does. And you'll find, a DIY will may very well be a practical solution. Let's say that, you're on your deathbed essentially.
Right.
And you need to put you don't have time to instruct an attorney to draft it. Just so long as it meets those requirements, as in it's executed properly, it's executed by you at the foot or end as your intention, your signature signifying your intention to create this will, and it's executed by you in the presence of two witnesses, then that DIY will, in the absence of any other will, would stand.
Yeah.
Got it.
So
Okay.
I guess, like you said, with the exception of being on your deathbed and needing to have that thing signed and drafted quickly, you would always recommend, no, you go to a financial advisor.
Of course, because there are certain nuances to drafting and creating wills that you may very well not recognize, and you can by taking it upon yourself, in any other circumstances apart from that extreme deathbed scenario that we've mentioned, you could vary. You need to understand. You need to that you could vary. There are certain pitfalls that you could fall into. For instance, you could, I think I mentioned this earlier, you could forget about your residuary estate entirely. And in relation to, and if you did not want it in relation to that particular portion of your estate, that would then devolve or be passed on as though you had not made a will at all.
Right.
Okay.
Right.
And then the very last burning question before I move on is, legally, in a court of law, can I leave out any person that I want to? Do I have to put certain people in my will, or can I say I want everything to go to one person or to go to whomever I decide?
Well, of course, it can be whomever you decide. And the reason for this is that in the Bahamas, we recognize a concept that's known as freedom, testamentary freedom. So essentially all that means is that I am entitled as the owner of these assets to leave them to whomever I want to leave them to upon my death. It does not have to be family. It can be friends. It can be, as in most cases, a lot of cases you hear in the Bahamas, I'm leaving all of my assets to the church. That is entirely fine. But then again, I must qualify that by mentioning that I believe it is under the Inheritance Act. If I have not made, let's say I have not made adequate provision in my will for my spouse or my children, an application can be made to the Supreme Court,
Right.
but varying that will so that they are taken care of.
Right.
Okay, so a will can be
Sorry.
Oh, and I was going to say a will.
Okay, I was just saying that the burden of proof will be on, let's say, the spouse, for instance, to prove that sufficient provision has not been made for him or her in the will.
Right.
Makes sense. Okay.
Yeah.
So conclusion, a will can be contested if someone feels that they have not been adequately prepared for in this person's death.
I think there's one more question we need to touch upon. I know
Okay.
I know we've been on wills for
are
quite
so
some time.
interesting. Yeah.
It's very interesting, and the time frame for going about this whole process with probate.
Probate.
That whole process, what is typically the time frame? Because I don't think it was mentioned, but even with a will, you still have to go through that process of going to court, correct?
Yes.
Yeah. So typically in a case where there is a will that was created, what is the time frame for that probate process? And two, if there is no will, you died intestate, what is then that time frame in that scenario for the probate process?
Well, okay, I'm going to qualify this by saying much depends on the complexity of the particular estate that you are dealing with. With probate matters, for instance, with a run-of-the-mill probate matter, for instance, from submission to the application to the issuance of the grant of probate by the Supreme Court, I'm going to say I'm going to say about it can be as little as 3 months.
Okay.
Okay, that's perfect.
Pretty quick.
Yeah, that's awesome.
But for the mom, that's very good.
Yes.
yeah.
No, and what I found lately, and much, of course, to their credit, the probate registry has been extremely responsive.
That's good.
That's good to
So,
know.
minimum 3-ish months, max. I guess it could go longer. So
Depending on the
depending on
estate and depending on whether or not it's contested,
Very
the will or anything of that nature.
Exactly, that is correct.
Right.
Okay.
Okay, so we want to move on now.
Yeah.
The wills were exciting,
Yeah.
but we're going to move on now to power of attorneys and enduring
Enduring
power of attorneys. And I think those terms sometimes are used interchangeably, but
Yeah,
there is a
actually different.
distinction. Yeah.
Yeah.
Yes. As you so very correctly pointed out, there is a distinction between
And so,
a
and
regular
you don't-
general power of attorney, of course, and an enduring power of attorney. And the distinction is this: with a regular power of attorney, that power of attorney terminates terminates if you become incapacitated. That is, if you lose, your mental capacity, it terminates upon that event. With an enduring power of attorney, the enduring power of attorney is meant to survive your mental incapacity.
I'm sorry. I think we kind of
You
skipped.
need to backtrack? Okay, I just want to say we need to
I
backtrack
think we
and
got
explain
to-
what they are.
Yeah. What is a power of attorney?
Correct.
Yeah, we didn't explain. And what is it?
Well, a power of attorney is a document that essentially allows me to grant a person of my choosing, power to deal with my assets upon certain eventualities that are specified within the power of attorney. So I may say that, okay, this person, I grant this person power of attorney to deal with my assets. I can say very well, in the event that I am outside of the jurisdiction for regular power of attorney, I can say that. With an enduring power of attorney, I would be saying that I grant this person the authority to deal with my assets should I become incapacitated.
So, seems as if the difference between a will deals with after someone has died.
Yes.
Power of attorney and an enduring power of attorney is a document that deals with someone while they're alive, but it grants someone else powers while that person is alive.
That is correct.
Is that it? Okay.
Yeah, you got it.
Got it. And I think because we tried to do as much reading as we could to make sure we're asking you, great questions that people want to hear. And under Bahamian law, it seems as if the enduring power of attorney document is specifically, it grants powers for someone else to control the financial transactions, anything financial related to that person, if and only if they become incapacitated. Do I have that correct?
Well, you can establish an enduring. Okay, you have to think of the word enduring in the sense. So an enduring power of attorney can very well operate like a regular power of attorney in that it is operative, while I am alive and while I am not incapacitated. But the difference between that and a regular power of attorney is that only the enduring power of attorney will continue to subsist after my mental incapacitation.
Okay.
Right.
So I guess to be more practical, I guess what circumstances would arise for me to say, hey, I need to go to a lawyer and create this enduring power of attorney document or create this power of attorney document? Is this for someone who has been, for example, been diagnosed with dementia? They know they will one day be incapacitated, so they want someone to deal with their business and their financial, I guess, workings during their life, but while they're incapacitated. Would that be an example?
Yes, that would be quite a common example of what would happen. And not only should you consider granting a power of attorney, just in the in the instance that you are in fact anticipating that you will degenerate because of some degenerative disease like dementia. You should also make consideration to that eventuality beforehand, because it's not only degenerative diseases that you have to consider. It's also things that I might walk out of the house one day and, God forbid, become involved in a car accident, or might have some catastrophic medical event for instance, a stroke that would render me incapacitated, things that are unpredictable.
Right.
So, of
I
course.
think too, I mean, we've seen even with this pandemic, how
Yeah.
quickly, if, for instance, you contract the virus, how quickly you can just end up in the bed and die right away. And so that is a testament of, I guess, how important it is to have this enduring power of attorney in place.
Yeah.
Because, like you said,
You want someone to be able to sign perhaps checks on your behalf,
Exactly.
to open up on your behalf, to do anything financial on your behalf. So yeah, that
Essentially to deal with your assets and your affairs,
correct.
should something happen to you.
So
Makes
a
sense.
power of attorney, well, let's go back to an enduring power of attorney. Can this document, I'm assuming it can be revoked. In what circumstances will the document end, be revoked? That certainly want to know that.
Yeah.
Well, for instance, you can specify, for instance, in your power of attorney that I'm granting this person, for instance, power of attorney for 1 year. So at the end of the year, for instance, the power of attorney is automatically, it terminates. So it's no longer valid after that year. You can do that. And a power of attorney, for instance, it could very well be revoked by let's say that you were under duress, for instance, when you were signing your power of attorney. Your power of attorney could very well be challenged on those grounds and, deemed void on those grounds.
Okay.
Okay. And you
No.
go ahead again.
No, it's kind of segueing. So I know you had
Yes.
another question on enduring power of attorney.
Right.
So I want to do a little segue.
Okay, you go ahead.
Yeah. Okay.
Yeah.
So, for example, we're going to take your example. God forbid you walk out the house and you have a traffic accident and you become incapacitated. So we know the enduring power of attorney gives someone the authority to deal with your assets. So what document would someone need if they are incapacitated to allow someone to make medical decisions on their behalf? Because you have to do the finances and then, of course, the medical care. And I assume there's two different documents. So what is that document called? What is that concept? If you could explain more about that.
Okay, so what that document is a living will or an advance directive. Advance directions as to what should happen to me, what I would like to happen to me medically, should I become incapacitated and be unable to make decisions for myself.
Right.
Okay.
So what is you mentioned these two forms of documents. Sorry about that. We have a phone ringing. Someone's calling. But you mentioned two things. You mentioned a living will and an advance directive. You've described what they're
the same thing.
They're
Just
the same
thing. They're the same thing. It's just, one is another word for the other.
Okay. Right. Okay. And upon our reading, both Lauren and I realized that these documents itself, we've seen that it may not very well be legally binding here in the Bahamas. I don't know what the position is regarding that. Are these documents legally binding?
In the Bahamas, I'll mention this first. In the Bahamas, we do not have a dedicated regime for living wills or advance directives like you would see in the UK, for instance. I believe under their Mental Health Act, they make provisions for the creation of living wills or advance directives. However, so here in the Bahamas, we do not have that. So advance directives in the Bahamas can more easily be challenged. And for instance, in the Bahamas, let's say what you've declared in your advance directive or your living will isn't in the opinion of a medical practitioner to be the the route to go in your best interest,
Mm.
then that can be overridden. That can be overridden in favor of the medical practitioners, sort of their opinion, because of course they're bound by law to act in your best interest as far as your health care is concerned.
Right. So I was just gonna say, I think it's so challenging for individuals in the healthcare system to have this overriding ethical duty to act in the best interest of the patient, but at the same time, this document may be in place where it's the wishes of someone to go about in this direction in terms of their treatment,
Yeah.
and they have to find that, I guess,
And
fine
let's give an
line.
example. For example, we know there are many COVID patients who needed to go on the ventilator.
Mhm.
I know many persons who say, I don't want to be hooked up to tubes. I don't want that. If I get to that state, let me go to the good Lord. I've heard many people say that.
Mhm.
So they have the directive, I don't want to be hooked up to a ventilator, to tubes. Because in the Bahamas, that document is not legally binding, I'm assuming a doctor can override that patient's wishes and put them on a ventilator.
Not only the doctor, as well as, your family might expect
Your family.
certain views as well. And, they may very well choose to go along with the views of your family. The doctor, of course, will make his decisions as to your, the best care that they can offer you, of course.
Okay.
So I have a question in terms of, let's say, for instance, this advanced directive is in place.
Mhm.
And we'll use this example again. Something happens. The care here in the Bahamas is not sufficient.
Mhm.
They have to fly out to the United States, which is in most cases where you go
Mhm.
outside of the jurisdiction. My understanding is in the US, advanced directives are legally binding.
Mhm.
So in
Depends
that,
on the state, perhaps. I don't know.
yeah, depends on the state, I guess. But in that situation, then, where you have I guess, an advanced directive document, which was created here in the Bahamas,
Mhm.
which is obviously not binding here in the Bahamas, but now you're in the US. In that situation, does it create some sort of conflict of law?
Yes, yes, you're entirely correct. It would create some sort of conflict of law. And I don't quite know how they would resolve that. To my mind, so long of even though your advance directive was made in the Bahamas, I believe in that situation, so long as, let's say, it can be reconciled with US law, for instance, I believe it would be taken into account.
Okay.
Yeah, but of course, I can't speak to what would happen in the US.
Right.
Correct.
Right.
And so it not being binding here in the Bahamas, where do you see the laws in any way changing now, sometime in the future, to make these documents binding?
Hopefully so.
Well, I would hope that we begin to turn our minds towards, for instance, amending our I believe it's called the Mental Health Act in the Bahamas, or either the Mental Health or the Mental Capacity Act. I forget the exact name. So that advanced directives, of course, can be recognized and be given and be seen as essentially valid.
Mhm.
Yeah, so I would hope that we move in that direction. But of course, what needs to happen is there needs to be a large enough group of persons advocating for that change. And I know that a number of doctors have, because I've seen quite a few statements issued by Bahamian doctors. Even if you go and read the archives in the Tribune or the Guardian, you will see that quite a number of doctors have gone on record saying that this is something that we need to consider, legislating in the Bahamas.
Right.
Yeah. I think we've covered that. I think.
Yeah. So we're gonna move on to
Lot structure.
trust, and
Save the best for last, I
yes.
guess.
So, Kamala, what is a trust? Some people may not know what that means at all. What is a trust?
Okay, so I'm going to put it in these terms. A trust is essentially an arrangement whereby I appoint someone, I transfer to them legal ownership of my assets so that they can use those assets for the benefit of someone else.
Mhm.
Okay, so I understand it's correct.
So just to put it into, just to illustrate it a bit more,
Mhm.
I say that, for instance, the money's in my bank account. You are to hold them as my trustee, but I want you to use those funds for the benefit of my children.
Mhm.
Okay, so in that case, if I give, let's say in this example, if I give you the ownership of my funds now for the benefit of my children, in this case, do I have any say over these funds, or do you now have the say over these funds for the benefit of my children?
Well, it would depend on the type of trust you have in place. So, for instance, if you have what's known as a reserved powers trust, meaning that you've reserved power to yourself, for instance, to make certain decisions as to how those funds should be disposed of, how they should be spent, then of course you retain some sort of say over what should happen to those funds. If you don't have a trust that is a reserve powers trust, then you've essentially handed over power to your trustee to make those decisions. If it is, a trust, a discretionary trust, which permits that trustee that sort of discretion.
Right.
Okay.
So, who would you say typically, I guess, what the typical clientele are suitable for then, you would say?
Well, I would say it depends. It really does depend on your own particular needs. What I found in my practice, for instance, I find that it's usually typically high net worth clients
Mm.
or people who have, a sort of a moderate pool of assets,
Mhm.
who would sometimes opt to have a trust. And they may very well opt for trust in different circumstances. Like I find with high net worth clientele, they have a trust that are established to be operative during their lifetimes. Whereas, they're one of the beneficiaries of the trust as well as they make provisions within those trusts for their death. For more, I would say, for lack of a better term, middle class people, you find that they tend to use trusts in wills, for instance. So their will have certain trust provisions in it. So let's say they have young children, or they have grandchildren. They may very well specify that I want X percentage of my estate to be held on trust for the benefit of my children or grandchildren, whichever the case may be, until they reach a certain age.
Mhm.
And in that case, after that, then of course the trustee is free to transfer over those assets to the children or grandchildren.
Mhm.
And just for confirmation, here in the Bahamas, both Bahamians and non-Bahamians can create trusts here for the benefit
Yes.
of whomever they decide. It's
Yeah.
not for. So I think there's a misconception where we think only rich foreigners create trusts in the Bahamas, but Bahamians can create trusts if it is best suited for them, of which they can decide with the lawyer or wealth advisor if they want to create a
Mhm.
trust.
Of course, and that, goes along with the larger conversation that we were having earlier of sort of shifting the culture and the thought of, of the Bahamians at large towards, putting your mind to planning your estate, to planning for your future and for future generations. So not only are trusts the preserve of the ultra wealthy, so long as you have acquired sufficient assets, you are, of course, you can make a trust. And trusts, the beauty of trusts are that they are quite flexible creatures. Whereas, for instance, it may very well suit a high net individual to have the expensive corporate trustee, the expensive trust company managing their affairs as trustee. For the average Joe, that may very well not be financially feasible.
Right.
So another consideration is that another thing that we should mention is that so long as a person is over the age of 18, they have a sound mind, they're not incapacitated, and they're not what's known as an undischarged bankrupt, you can appoint them as a trustee. So that means that, for instance, you can appoint a close friend of yours as the trustee of your assets. You can appoint, your parents. You can, your siblings. So it's unlimited in that sense. So you don't necessarily have to go the flashy, expensive corporate trustee route with the full-fledged trust company. You can, look at certain individuals with close proximity to you to fill that role.
Mm-hmm.
Awesome.
Yeah.
Okay. So I think the last point.
Yeah.
Last.
Really is that
Yeah.
you mentioned it, future, thinking about the future.
Mm-hmm.
And we wanted to touch upon this point. We thought this was important. Digital assets. We're seeing now cryptocurrency. We're seeing all of these different assets that are not the typical assets, like a piece of property or cash in your bank account. How does moving towards that digital assets now affect estate planning? Does the typical vehicles in which we discuss have a role? Can it complement? Can it digital assets be incorporated in these types of vehicles?
Your Bitcoin or your other digital assets in a will, in a trust.
Yes.
In a POA.
Yes, of course. That is your property. So of course you can you can grant you can gift your digital assets to whomever you choose under your will or under your trust, and there's no prohibition on that as far as that is concerned. Now what comes along is that because I guess digital assets they're relatively new. They've only come to prominence within I would guess say the last decade. Many people sort of don't understand digital assets, how they're used, the value attached to them, or even, there's certain complexities in relation to accessing digital assets. It gets very technical, using the wallet, or using, password keys, so it's that sort of thing that you need to consider. So, for instance, with a number of corporate trustees here in the Bahamas, you will find that many of them are very risk averse to dealing with trusts, for instance, that have cryptocurrency in them. They prefer not to deal with them because of the volatility and value of those cryptocurrencies, and also as well as, like I said, the whole the technical aspects of accessing them. So go ahead.
Go on. I was just going to mention that both Lauren and I read an article just recently in the New York Times where an individual, he was gifted, I think, 7,000 Bitcoins back in 2011 when it was, I guess, in par with the dollar. We know that Bitcoin now is, I think, worth $37,000 per Bitcoin. Around there. And he has lost, like you mentioned, the password to gain access to his Bitcoins, which is worth over $250 billion right now.
So he can't give those to someone if he wanted to, because he can't have access to them.
Oh my God. Yes, it's very, so it gets, as you can see, when you're dealing with estates which have cryptocurrency in them, it can get quite technical. I know we didn't get into this earlier, but for instance, when you're dealing with, just a regular layman who may not have, or who may not be quite knowledgeable or tech savvy when it comes to digital assets, when you're appointing that person as a trustee or as an executor, they may feel very uncomfortable dealing with the administration of those assets. And that's where, a trust can be quite flexible, for instance. So you can appoint an investment advisor to assist the trustee in relation to handling those sorts of assets.
Super interesting.
Yeah. Well, I think that's in
I think
terms
we've
of.
wrapped up. We talked about wills, POAs, and during POAs, we talked about trusts. We hit on digital assets. So
That covers everything. So,
yeah.
Kamala, we're just ecstatic that you were able to join us today and really, like you mentioned, shift the minds of Bahamians and others worldwide on estate planning, of considering this now. The time is now to start estate planning. And so we just want to thank you for coming on the show today, for educating us and educating the viewers. So thank you so much for coming on.
Of course, you're both welcome. And, if you guys ever have any follow-up questions, then you know how to reach me. Just feel free to, send an email and I will address them.
Well, do you have an email address? Because I know we had some viewers here and they may be interested in reaching out to you and getting legal advice. On estate planning.
Oh, well, of course, you can reach me at my email address, which is K Richardson, the letter K Richardson at higgsjohnson.com. And I'll be happy to assist you and answer any queries that you may have.
Fantastic. And we'll definitely put that in the description as well, so that if anyone is interested, they can reach out to you as well. But thank you, everyone who was viewing and watching the show today. We hope it was informative to you. And stay tuned to episode 2
next week, Saturday,
at
same
4
time,
p.m.
4 p.m. So see you guys.
Take care.
Bye. Thank you, Kamala.
Of course, you're welcome.
Okay. Wow, perfect.
So now how do we...
61. I don't know how. 61. Stop it.